Hello everybody. This is a video that will wrap up our court lectures that we started on Wednesday and we had today, and I didn't have quite enough time to finish up the last few points, and so we're going to go over the slides that you did not get to go over in class. And these slides, of course, will be posted as well to D2L, so you can catch them there, or I'll email them to you one way or another. I'm attempting to try out some new video aspects of it. That's why you get to see my face, which will either repulse you or keep you riveted to the screen. So we're going to try to go in and out along this view to see how it works. So we're going to dive back in to the 7 things or 6 things I think it is that you need to know about the judiciary. So depending on which class you were in, this is where we left off on our lectures. For some of you, we've already covered this, but I think it's okay to sort of lay ourselves on it. When the court makes decisions, as we've talked about in the past, they operate the idea of precedent. That is, that the decisions of former cases, of earlier cases, especially decisions by the Supreme Court, hold precedent. That is, we would decide current cases and future cases based on past cases. Lower courts do this almost exclusively. They base their decisions on Supreme Court decisions in the past, and the Supreme Court also takes precedent very seriously. They're very reticent, or they're hesitant to turn over court cases. We call this stare decisis. That's a Latin meaning for let the decision stand, of course, and courts are expected to follow this along the way, and it's very rare that the Supreme Court would fully overturn a previous court case. We have examples of it, but it's not very often along the way. Once a court decision is made, and when courts cases make their way to the Supreme Court through a decision by accepting them through issuing what we call a writ of certiorari, or a writ, or a cert. That is, if you wish to appeal a case to the Supreme Court, what you are asking them is to issue a cert regarding your case, saying that you will be listening to the case. In most cases, the court is going to listen to a case because they're hoping to clarify some confusion or inconsistency in lower courts' decisions around a particular case. In other words, the ideal goal is that all of the appellate courts and district courts below them would be deciding cases on similar logic and on similar reasoning as all other cases. And when that's not the case, the Supreme Court's looking to clarify those particular questions that come up along the way that are inevitable to come up. So that's what they're looking for along the way. And they call up cases based on what's called the rule of 4. That is, if 4 justices want to hear a case that's been appealed to them, then the court will hear the case. Once the court hears the case and gone through the process, and we'll get into that, the decisions themselves are made by, or won or lost by a majority vote. That is, there's 9 members of the court. If 5 people agree in one direction, then that is the decision of the court. And the decision itself is, of course, extremely and primarily important. But more importantly, the bigger part of this is the written decision that explains their vote. The written decision that explains the logic of their vote, of what they meant. And these decisions are very important in future cases. We call these opinions. That is, we call the winning side of it and the opinion they write the majority opinion. We have concurring opinions, which are opinions that either agree, if it's on the majority side, a majority concurring opinion would agree with the majority side but want to add its own spin on the decision. And there's also dissenting opinions, which are basically the losers in the case, the dissenters, and they give their opinions for why they think the case should have been decided in a different direction. And it's these opinions that lawyers and courts use, lower Supreme Court, but also the appellate courts and the district courts, use to decide how to guide them on how to decide future cases. And so this is why lawyers look at cases and they read the decisions, because they're looking for the logic and the guidance that these decisions made. So well-written decisions, right, will provide a large amount of clarity and guidance along the way. Poorly written decisions or vague decisions sometimes don't provide the necessary guidance and clarity along the way, but it provides sort of the legal reasoning for how this goes along and works. Now, this is where we'd have a clip on the Daily Show. It's not that important. One of the classes saw it, one of the classes didn't. I'm not going to post it up, but it's sort of a funny way to look at court decision making along the way. Appointing of judges is the next thing you need to understand about the courts. Of course, judges in the federal system are appointed by the president and confirmed by the Senate. At the state level, there's a variety of different ways in which judges are selected or even elected, as in the case of places like Pennsylvania and some other states. And judges are appointed for a variety of reasons, but usually it's just a battle over ideology. That is, they're looking to appoint someone that has a similar ideology in terms of understanding the law and the Constitution as they do or as their party does along the way. And so typically a Republican president who successfully appoints and gets confirmed a judge is appointing and getting confirmed somebody who agrees with Republican ideology in general. And the same thing on the other way, a Democrat would largely appoint a more liberal judge as well. But they often have to contend with a Senate that is from their opposite party. The Senate is the one who gets to confirm them. And so this provides a sort of an additional check, and that is supposed to prevent sort of radical decisions or radical appointments along the edges. In terms of the lower court appointments, especially in the circuit court, but actually in the district court as well, the city, and we've talked about senatorial courtesy already, but the president basically, if there are senators in the state where he is making the appointment from his party, he would offer the senators an opportunity to weigh in on the decision. So the example I used earlier in class is if President Obama was appointing a judge in California, the two senators from California are both Democrat, and he would consult them or offer them senatorial courtesy, we would say, to weigh in on this particular decision along the way. In general, the appointments are not particularly diverse in terms of ethnicity and gender, but the court has become much more so in recent decades. There are now 3 women serving on the court. Still not parity within this. We have 1 African American justice, 1 Latina justice. But in other ways, the court has become less and less diverse in a couple directions. One is geographically, the court, all the members of the court are either from the East Coast or the West Coast, nobody from the middle of the country. And geography used to be a big consideration in appointing a justice, and now it's a non-consideration. In terms of schooling, all the members have come from private elite schools or have gone to Ivy League schools. And in fact, I think they may have all gone to law school, or one of their degrees comes from an Ivy League school. Kennedy went to Stanford at some point, but I can't remember if that was law school or undergrad. But the vast majority have gone to either Harvard or Yale law in many ways. So religiously is the one I find the most interesting thing. All the members of the Supreme Court, all 9 members, are either Catholic or Jewish. There are no Protestant members of the Supreme Court, even though the largest religious denomination in the United States, Christian religious denomination in the United States, is mainstream Protestantism. So this would include Baptists and Methodists and Lutherans, etc., Episcopalians, and there are none on the court at this particular time. So this is kind of an interesting aspect to it. Appointing judges can be a very contentious activity for the President of the United States trying to get this done. It's usually it involves a very large, heavy battle. What I want to do next, the final point that I want to delve into, the final main point, the 6th point, is looking at a dynamic in the court that you as a citizen have either paid attention to or will in the future. It's part of the major ideological battles that happen in the court, and that is around ideas and the interest or the motivation of judges or their preponderance in terms of being willing to interpret the Constitution in different ways. And these are sort of 2 different dynamics that we're going to look at. One is about originalism versus interpretive nature of the Constitution, and another one's about judicial activism versus judicial constraint. I want to take a minute now to try to explain those difference of these 2 things. So, the first of these dynamics is the idea of originalism versus living constitutionalism, or we might call pragmatism along the way. And this dynamic is one that's often battled over and talked about in the courts. Originalism is the idea that members of the Supreme Court should only make decisions solely based on the literal meaning and words of the Constitution and the intention and votes of the authors of the Constitution or the authors of amendments to the Constitution. That is, that's the only information that should be used on the constitutional side in deciding contemporary cases, even if those things aren't mentioned in the Constitution. So if we're trying to decide a case on the web, you should do your best under an originalist formula to literally try to understand what the founders meant, what the Constitution literally says, and applying it in today's situation. Their argument would be that if Congress wants to adjust what it means in a contemporary setting, they should amend the Constitution, if that's the case. And if they don't amend the Constitution, then the court, it's not their role to try to interpret it in a broader way and apply it in these sort of broader ways, or assume what might have been said, or provide a looser interpretation of the Constitution. The opposite of this, and again, we run on a spectrum, nobody's one or the other, is living constitutionalism or pragmatism. And this is the idea of focusing on what we mean is sort of the more general principles of the Constitution and find a way to have them make sense in a contemporary setting. It basically relies on the idea that the Constitution was intended to be a broad document with general descriptions, and indeed the founders in many ways defined it as this because they knew society would change. And so that vagueness allows us to apply it and interpret principles in a more modern setting. A classic case would be Roe versus Wade, and Griswold versus Connecticut, which deals with birth control and deals with abortion. And both those are based on the concept of the idea of privacy. Now, privacy is not mentioned anywhere in the Constitution or in its amendments, but we can get from that a reasonable understanding that the Constitution intends a serious level of privacy within the nature of the Bill of Rights, or most or several of the Bill of Rights. The founders had no concept of how our privacy and how things would change 200 years later. It's radically different. And privacy was a much easier thing to maintain in 1787 than was in 1978. And so, under a living constitutional view of interpretation, you should be able to get an idea that they intended for a substantial amount of individual privacy as part of your individual freedom, and be able to apply that to current life. And so we often see that as one dynamic. In general, although I don't think it applies this way, but in the news media, originalism is typically attached to conservatism, and living constitutionalism is typically attached to more liberal views of the Constitution. That being said, I think these two viewpoints get used in a more political. If originalism fits your needs and helps you make your argument, then you embrace originalism. If living constitutionalism embraces your argument, then you do that. For instance, the Second Amendment, by most standards, did not provide the kinds of protections that we think of today. The founders had no idea of submachine guns and bazookas and a variety of things. And so we have to interpret what they meant by it. So it means something different in this particular context. And we have found a sort of living constitutionalist way to interpret the Second Amendment along the way. But that is a conservative interpretation that embraces living constitutionalism to apply it. The second one, and this one gets detailed in the book a little bit, is judicial restraint versus activism. This has more to do with precedent than anything else. Under judicial restraint, there is a tremendous amount of respect for precedent to both legislatures, the law, the Constitution, as well as decisions, but really mostly around allowing political decisions to stand, allow legislators to sort things out, for the law to be what the law is, and very limited interest in changing what a legislature has decided. Judicial activism, on the other side, is more interested in developing new legal principles. It's okay to interject and change decisions made by legislatures, especially when the need arrives. It's okay to bring up new precedent and overturn old ones along the way. Again, with these, we typically correlate judicial restraint with conservative or Republican ideas and judicial activism with liberal or Democratic ideas. But in reality, these two views get embraced depending on how it fits your needs. Um, you would see under a restraintist model that the court would stay out of something like Obamacare, the Affordable Care Act, because they would say, well, the legislature decided it, and we should let the legislature decide what they'd like to do. But in reality, the conservative judges would embrace a more judicial activist view of it, right? And liberal judges would embrace a more judicial restraintist view of it. So be very skeptical when we try to make these things labeled to one group. The group embraces that aspect of it that will meet their needs in many ways. But this is an important dynamic, and these dynamics are the things that get talked about most when we talk about judges along the way. So that wraps up most of what I wanted to show you on these slides. But I do want to show you this one last chart. This is not in your book, and the book doesn't spend a lot of time on this, but this does give you some sense of the flow of the Supreme Court decision making and some of the aspects of it. And I want to point these out, and I'll point out anything you might need to know for the exam that is tied into it. But you get an idea about the court cases that flow in. These are people that submit petitions to the Supreme Court asking them to consider their case. About 8,000 of these come in a year. The justices, along with their staff, which includes law clerks, and the book talks about law clerks, so understand the role of law clerks, make recommendations to the judges. Law clerks make recommendations to the judges. The judges have a short list called the discuss list. And the vast majority of these appeals get denied, 98% of the cases in general along the way. The cases that get heard because of, as I mentioned before, the rule of four. Four justices say it's accepted that it should be heard, and so it gets heard. The cases that make it through it, about 100 a year, are put on what we call the docket. A docket is established every year. It's about 100 cases, and the judges say, this is what we're going to listen to. They set a date for the oral arguments, and they move forward from that point. So extremely small amount of cases. Once those cases have been established, that is, those cases have been issued a cert or a writ of certiorari, they're allowed to submit written briefs to the court. That is, their written argument to the court along the way. Then at the next stage, you get the famous oral arguments where you actually, each side comes up and gives an oral argument to the court. These oral arguments are limited to 2 to 30 minutes each. Each side gets 30 minutes. Hard timed. It is like there's lights in front of you on the podium. When the light turns red, your talking stops. And judges are allowed to interrupt you during this time period and occupy your time, and you still only get 30 minutes. And that's done by an internal rule. The court, occasionally that's changed, but it's very rare. Once the oral arguments are done, the Supreme Court meets together in secret, and a variety of other things come in to affect the Supreme Court decisions or to help them weigh in on it. Part of this is what we would call an amicus curiae brief. An amicus curiae brief, this might be on the exam. An amicus curiae brief, which could get filed at this point or might be filed at this point to hear the case be heard, are briefs from organizations that are not part of the case but have an interest in the case. So let's say it's a gun rights case. It's likely the NRA would file an amicus curiae brief, what we call an amicus brief, to the Supreme Court to tell them why they think the Supreme Court, why they think a court case should be decided in a certain direction. If it was an environmental case, it may not be unusual for the Sierra Club or Greenpeace or any number of environmental groups to file an amicus brief as well. So we get lots of amicus briefs within this. So pay attention to this. They look at other things like precedents and public opinion and their own beliefs and a variety of things that go on. And this is sort of a secret negotiated process. Once the courts have been decision, they write the decisions. Once they made a decision, they write the opinions, both the majority and dissenting and concurring opinion. And then the opinions are issued and published by the court one by one during the judicial season, which you'll notice will primarily take place in the spring. The heavier load takes place in the spring. So that gives you an idea of how these flow along the way. The final slide, I'm just real quick to show you. Just be sure to understand these concepts. These are all definitions in the book. Be sure you understand them. Common law, which is the idea of using precedents. Civil law, which are lawsuits between two individuals. Criminal law, which is when an individual breaks a standing law that the government has. That is, it's a case that's brought against an individual by the government. A plaintiff is the person who has been harmed and might be suing the other person. A defendant is the person who's defending themselves against a charge. Be sure to know those particular terms. But other than that, good luck on the exam and good luck in studying.